And we're going live.
Okay. Hi, everyone. This is Ruby Powers, and it is Friday, April 9th. We are talking about complex immigration naturalization issues today. And we're just starting a couple minutes late. Thank you for your patience. But this is a really important topic because this is ultimate goal for immigrants. You generally, right? We want to get to citizenship. So how do we overcome the complex naturalization issues, and when do we hire an attorney? I did a presentation for Lawline recently on a similar topic, and also I helped out at the Baker Ripley Naturalization Clinic, and it just made me think. It just made me think more about naturalization, and this is a very important topic. So, a little bit about me. My firm is 12 years old. I've been practicing 13 years. I'm board certified, and I do a lot in the advocacy, law practice management, and talk on all different subjects of immigration and regularly in the media, and also wrote a book about law practice management. Okay, let's move on. So I want to talk about the path to citizenship, how to overcome the obstacles. When is it considered more complex for naturalization? When are some red flags that you should know? You should definitely go talk to an immigration attorney. So the basics of eligibility requirements, as well as some of those red flags and concerns. So we like to put a lot of learning objectives on here. What is naturalization, derived and acquired citizenship? Maybe you're a citizen already and you don't know it. I've seen that happen. And then just some other talks about good moral character, permanent bars, what happens if like an N-400 is denied. So we're going to cover a lot in a short period of time. This isn't supposed to take the place of a consultation. So please do call us at 713-589-2085. We're also open on Saturdays to schedule a consultation, and we are starting to open in person. But you can also talk to us over the phone or Zoom. And so let's go ahead and dive in a little bit more. So naturalization is the process where U.S. citizenship is granted to a legal permanent resident, and they have to meet the requirements that's laid out in the INA. And so the basic requirements are that you're at 18 years of age, that you've had the legal permanent residency for 5 years. And if you're married to a US citizen and live with them, you can use the 3-year rule. One thing to note about the 3-year rule is that I might be getting ahead of myself, but basically under the 5-year rule for the residents, you can apply a little early um, if all things are met. But for the 3-year rule, you can't do that. You need to wait till you've been married and living with the U.S. citizen for the 3 full years. If you apply too early, it'll be rejected. And I've seen some consults on that, and also seen some people make mistakes on that. So good moral character is important, and basic knowledge of US history. That's why they give you that. There's 100 questions they ask that they have on the internet, and they only ask 10. If you get 6 of the 10 right, then you can move on. They have you read a sentence in English and write a sentence in English. I would say it's probably maybe a second, third grade level. And after that, you conduct the rest of the interview in English unless you meet the requirement that allows you to do it in another language. Um, so you need to have lived in the US for the required amount of time, and been continuously permanent resident in the US for at least 5 years, 3 if married to a US citizen. And so physical presence, we'll go into that. But basically, if it's 5 years rule, then you use 2.5 years plus a day in the last 5 years. And if you use a 3-year rule, you use 1.5 years plus a day in the last. And you need to have lived at least 3 months in the state which you're filing for USCIS to have jurisdiction over you. Now, just a real quick little detour on the conversation is that some people acquire citizenship at birth through let's say they've lived their parents were living abroad, they were expats or what have you. One parent was American, one wasn't, whatever. And then the child was born, whether in wedlock or out of wedlock. And depending on this, it gets a little crazy here, but we have to look at what year was the child born, what was the marital status of their parents at the time of the birth, which parent was the mom, the dad, who was, or which parent, the one that gave birth to them. And now things with surrogates and same sex marriage, things are a little bit different than they were back when a lot of these charts were made. But basically, the question, we look to a lot of those factors to see if the child acquired citizenship at birth or not. And then if they didn't, did they possibly derive it later on? And I've had cases, and I have one right now where a person applied for citizenship, of naturalization, and then when he got to the interview, they denied him because they said, you're already a citizen, go apply for the N-600. And so this is something we always need to check for. Maybe you're a citizen already. Many people, it's happened before where people are U.S. citizen and they didn't have proof of it, and maybe they didn't even know it. So we need to screen for this. And so we won't go into a lot into this, but basically, if it's a possibility, we want to rule that out, because if it is, then it would be better for you to apply for an N-600, which is a certificate of citizenship, and or apply for the US passport. And in my experience, it's good to do both of them. But it can be complex. So you definitely want to have an experienced immigration attorney to go over this with you. And then this is another thing that happened that started in 2001. So this is about 20 years old now. But if a child was born outside of the US, they can automatically become a US citizen when all of these conditions are met, and have been met on or after February 27, 2001. So some people, they are too, well, let's just say they're older than this doesn't apply to them. So just make a note of that. A lot of times when people Google this, they see this and then they think it applies to them. But really, if you are over a certain age, this wouldn't even apply to you. This was created because there were so many people who thought they had been passed on citizenship, like adopted children, things like that. And they realized that they hadn't actually gotten the citizenship. So it's if at least one of the child has at least one parent, including adoptive parent, who is a U.S. citizen by birth or through naturalization. The child is under 18 years old. The child is a legal permanent resident, and the child is residing in the U.S. in the legal and physical custody of the U.S. citizen. So I bring this also up in the realm of naturalization is because we also have cases like this where the parent is naturalizing and we're in a rush to get them naturalized before one of their children turns 18. Because if that parent can naturalize before that child turns 18, then the child, it's like a 2-for-1. The child can get citizenship based on it meeting all of these qualifications. Um, Okay, so one other thing to be cognizant in the complex naturalization and citizenship realm is that if a person was born to a midwife near the Mexican border, which is something we see a lot here in Texas, is that could be put in question if they were on a list of people who were not, who had given false testimony about where the location in which the children were born. And also if there's a delayed US birth certificate. Now, most people don't even realize this is a problem until they try to petition for somebody, and then USCIS starts giving them a hard time about their birth certificate. Or two, people apply for US passports, and the passport office, which maybe previously gave them a passport, decides to not give them a new one. And then this comes into play. And then later, I've had cases where people had to naturalize or go another route, maybe even adjust through someone else because their spouse or relative, because they realized they weren't a citizen. So this isn't directly related to naturalization, but it is something that comes in the realm of complex issues. So criminal matters can affect you because they could either make you deportable, or they can also affect your good moral character. We're not going to go into a lot of detail, but basically, we'll go into some things to note. So you need to, there's certain things that are bigger issues than others. So murder, aggravated felony, almost always those are going to be issues. The only exceptions could be if they were a long time ago before IRA. But I would say if you're in those realms, then you definitely need to review. And in most cases, that's probably not going to lead to be eligible for naturalization. But the laws did change over time. The statutory period for almost all cases of 5 years of good moral character. So I say to people, look behind your shoulder. In the last 5 years, have you had any crimes? Where was it completely resolved? Was there an incident? And so the list of good moral character, there's lots of things you look at: the crime of moral turpitude, fraudulent activity with green cards or documents, controlled substance. They even consider habitual drunkenness and gambling an issue. And failing to pay child support or alimony payments or to pay taxes. These are all, so if you have any of these issues that you need, because the case law is always changing, I would just say, come have a consultation, bring your records. Failing to support dependents, let's see, smuggling aliens, not doing your selective service when you were supposed to. And if you've had jail time of 180 days or more, if you have any of these instances, have a consultation. Basically, that's what I'm saying. And so if any of these things come up, you want to have a consultation. So let me just also mention one other thing about crimes and matters of these nature. If you have admitted the elements of a crime, then that is a conviction for immigration purposes. If you have an expunged criminal record, it still could be a conviction for immigration purposes. If you have any criminal matter whatsoever, USCIS is going to want a copy of it for naturalization purposes. So if you go something expunged, you're going to want to go get that record and have it so that you can submit it and show it, or you're going to have to show the absence of that record. So proving good moral character to try to overcome any lack of moral character, showing family ties, absence of other record, like let's say there was some criminal record, but it was a long time ago, 10, 20 years ago, everything's good now. Employment history, time in the country. So when it comes down to discretionary factors, those are things that you need to concern. There are certain things that are automatic bar to a permanent bar, and that you would never be able to apply for naturalization. In fact, could even lead to deportation. So we definitely need to review that with you. The other thing to note is, so this is about physical and continuous residence considerations. So bottom line, when you apply, you need to have lived in the US the majority of the time, and the period of time that you had to have the green card for. So I just did a quick math here for us, right? 365 days times 5 is 1825. You divide by 2, so you have to be the majority of the last 5 years here. So let's just say it's 913 days. So when you're working on your little chart about how long have you been in the US, this is really more of a concern for my expat clients, people who are living abroad extensively. We need to find the dates that show that you've been here at least 913 days in the last 5 years. And if you don't have that, you might just need to stay put in the US for a little bit longer until some of that time being out starts dropping from the last 5 years. So it's like a look back. In the last 5 years, have you been here 913 days? For some of you, that's like, yeah, no, that's a no-brainer. But some people, we're counting down the days. So the other thing is, if it's the 3-year rule, then it's 548 days. So if you're in the US at any point on that day, then you get credit for that day. But honestly, we don't like to have to count days like that, like down to, well, we've got 914 days. We're just here by one day extra. No, we don't really want to do that. We'd want to make sure there's a nice cushion so that no matter who counts it, they can still find that you're still good. And then the other big thing to mention is that you will need to qualify at the time we file and at the time you go to the interview. So like if you're good at the time we filed, but then you go travel a lot, and then by the time you have the interview, you don't have the time, then you could be denied and have to apply all over again. Okay, taxes, love taxes. They love taxes. Have you failed to file? Have you ever filed as non-resident? All that stuff. The bottom line is make sure you've never failed to file. If you ever were late to filing, but you filed it later, then that's not failed to file because you filed it eventually. So, but the biggest point is that if you owe money, you need to have a payment plan by the time you have the interview. And so that's just basically it. Pay your taxes. It shows good moral character. It shows that you've been in the US, and if you owe, have a payment plan. Now, if you ever made a misrepresentation of a false claim to citizenship, that's a serious matter. And if it was before 1996, then that could be a typical misrepresentation and not technically a false claim, the consequences of a false claim. But there are some ways that are waived. Some things like cancellation of removal, I can think of, or U visa things, those can waive those matters. But this is definitely another red flag. Go talk to immigration attorney. And just to go into a little bit more nitty gritty, sometimes there are exceptions to the false claim to citizenship, not just being before 1996 or waived for some other provision. Some people thought they were citizen because that their parents told them, or so there's some other exceptions, but we definitely want to make sure that we have that figured out before we apply. So one other thing I want to mention about misrepresentation in that space is that if, let's say, you say something wrong and correct, and you don't correct it in the interview, and USCIS finds that's a mistake, then they could ban you or bar you from applying again for 3 or 5 years for good moral character if they find that you gave false information on your naturalization application. So we often have people come to us and they've either filed before and they didn't have the travel, they miscalculated the dates, or they might have had some misinformation, and then they were told that they didn't qualify under good moral character and they needed to come back. Now, let's just talk about what would happen if you apply and you go to the interview and it gets they don't approve it on the spot, and eventually maybe you get a denial. Well, you can do an appeal. That's the form N336. Now, if you get a denial for N400, and you can come to us, go to an experienced immigration attorney who can go over the denial with you. And you have to quickly, it's usually with like 33 days, go over and figure out, is this something I want to fight or not? If it's something that's winnable, then sure, go ahead, because otherwise you're going to have to wait another year and a half for something and pay more filing fee for it. But if it's something that you're not going to win, an experienced immigration attorney can tell you that, then you might want to just let it go. But sometimes a denial can lead to immigration court, and that's something you need to be prepared for. So it doesn't mean all immigration court's bad. It could be that we've had cases where the person shouldn't have gotten their green card in the first place. They applied for naturalization at the interview, they figured that out, and then they got denied, went sent to court, but there was a waiver for it called the 237A1H, and we were able to get it approved. The great thing about that is the approval starts, the green card is valid from the day she originally got the green card. So we don't have to wait a long time, go back to naturalization, and you become a citizen, just get that cleaned up. But when I speak of that, I just want to say is that the reason why you do want to have an immigration attorney, if there's any doubt whatsoever, and of course I'm biased, I would say always have one, because I'm a U.S. immigration attorney, but it's because this is the last chance for USCIS to figure out if there was a mistake. And maybe you're putting yourself, your green card, your family's life, everything in jeopardy by applying. So some people think, oh, it's simple. I've had the immigration journey all this time. What's another form? I'll be done with it after. No, because this is the last chance for them to see if there was ever a mistake, and something you don't even realize could be a big problem. It is a big problem, could potentially be a big problem. So a denial could just be as simple as, oops, apply again later, or it could lead you to immigration court. There are other things when you might have to get federal court involved, but that's just something that you would need to discuss. So with an immigration attorney, where we could go into more detail, is this something worth fighting? So when, an immigration attorney should know your local office and other practice tips along those lines. Basically what we do when we have a consult is we screen you very well, make sure that we have the evidence we need, especially if there's an issue. If you've ever had a prior application, we go over that with you to make sure that we don't have the same problem again and how we can rectify it. We have to ask some questions, so might seem a little bit like intrusive, but how did you get your green card in the first place, and how did the person got you a green card, how did they get it? So because sometimes there could have been a mistake somewhere, hopefully not, but we just want to screen through all the potential red flags, go over travel history. We have extensive history with expat clients who traveled, they have reentry permits, they've been in and out. And so we can help clients with that. We need to make sure if the status was ever abandoned before. And if we have to, we'll do Freedom Information Act requests. And we'll double check that you're not a citizen already. And there are some cases where you can expedite the naturalization process and not have to wait the 3 to 5 years. And so that's there's another thing that we can screen for if your spouse is working for a company that qualifies or entity that qualifies, and or some cases with the military. So unless we will take any questions you have, we've gone through a lot of material. You can follow us at Ruby Powers Law. We do the Powers Hour Tuesdays at 5 and sort of get ready for the webinar and also talk about anything that's going on in the news for the week. And then we have our weekly webinars at 11. And today we are going to do this same speech in Spanish just as soon as I'm done. So thank you so much for watching. If you have a question, you can put it in the Q&A or in the chat. But you can also reach us at 713-589-2085. You can email us at contact@rubypowerslaw.com. And again, my name is Ruby Powers, and I'm the board certified immigration attorney. And we talked about complex naturalization issues. I mean, I think the biggest takeaway is that there's no harm in just having a consultation, making sure if you more of a clean cut case, or if there's more complications or red flags, just to know what's going on, processing times, any other things. And another thing is if you have a consult and then you decide maybe to file on your own, we also do prep clients, people who filed on their own, and we also go to interviews with them. So if that is another possibility, if you're having some questions as to whether you need some representation at the interview at the final stages. So thank you so much for watching. Please stay tuned for more webinars. And you can also sign up for our newsletter that comes out in English and Spanish every other week on our website, or you can do this little icon for the newsletter. So thanks so much for watching and have a great weekend.